Court does call the case People versus Serrano Johnson.
Public Defender Chelsea Vergils with and on behalf of Serrano Johnson. Mr. Johnson, please state your name.
Serrano Johnson.
I mispronounce your name every time, sir.
It's okay.
I apologize.
Thank you, Your Honor. Today is the time and date set for a probable cause.
All right, pause here. This isn't just your average court date. This is a probable cause conference, where the judge decides if there's enough evidence to move forward. And right out the gate, Johnson's attorney wants an adjournment, red flag, or fair move. You tell us in the comments.
And I'll accept that. Before imposing any sentence regarding that, I'm going to ask this question. He has indicated that he had old duels. So my only question is, does your client wish to stick to that story, or does he wish to tell me the truth?
Wait, so we've gone from I had a duelist to okay, I had beer in under a minute. Classic courtroom pivot. But here's the thing, truth in bond violation hearings isn't optional. It's everything. Think he thought he'd get away with it? Let us know your verdict below.
Are you tell me that? So did you tell them that?
Yes.
That you had old duels first and then had beer?
Maybe I omitted the beers, but yes.
What?
I omitted the beers.
Hold it. You know what, sir? Don't play fast and loose.
I got
The
it.
story.
I consume alcohol.
I know that. You lied to them. Did you even have no duels that day?
Yes.
How many?
6.
And then how many beers?
2.
So why didn't you tell them that you had the beer?
I just omitted.
Pardon?
I just didn't. I was afraid of what might happen. I thought I could pass.
Yeah, I would be too, because you're violating your bond condition.
Indeed.
The judge is doing math now 25 duel S in 1 hour just to hit that blood alcohol level? That's not just implausible. That's physically impossible. This is the court equivalent of saying your dog ate your homework while your breath smells like hops.
Use the bathroom because you couldn't eliminate in order to get to that level. That's how stupid your story was. And now you can't even, you can't bring yourself to say that you were intentionally lying to them and attempting to mislead them. It was not just a simple omission. Counsel, what did you want me to do with this case?
Regarding the probable cause conference, we're asking for a 2-week adjournment so that he can show that he's going to comply with the court's orders.
Well, I don't think he's going to have a choice on that, quite frankly, Mr. Allen.
We are asking for him to remain out of custody today. This would be his first bond violation. He is here to be honest with you, although the truth doesn't always make sense.
We're hitting a turning point now. The defense is pulling every string. He's a business owner. He volunteers. He's remorseful. But the judge isn't buying it. And honestly, this is where courtroom reality hits. Good character can't always undo bad judgment.
Is very open to treatment. He understands that he has a substance issue and he wants to get help for that. And he's a business owner. There's a lot of pressure on him. He provides for himself and his family. He also does volunteer work, not court ordered, just out of the goodness of his heart. He is open to treatment, substance abuse, counseling. He plans to seek that regardless of whether the court orders it or not. We're asking you to keep him out of custody with a scram tether. Again, this would be his first violation. And he's asking for the opportunity to show compliance while out of custody.
Anything from the people?
Your Honor, we do have some concern about Mr. Johnson's ability to comply with the bond conditions. As stated, this is his second offense. I think it's just a couple of years. We would note that in this case, he allegedly was found not awake in a vehicle that was in the street with 2 guns on him, although he's only charged with 1 CCW. So we do have some concerns about whether he's able to comply with those bond conditions.
Anything else?
Your Honor, I just think that he would have a better opportunity to get the treatment and help that he needs out of custody.
He first has to admit that he has a problem.
I
The
do.
way that he does admit that